Well, good morning. It's 10 o'clock, so I'm going to go ahead and get our presentation started. I know we'll have more folks joining as we move along. Welcome. I'm Pat Miller with Sherman and Howard, as you know. I'd like to welcome all attendees to the first of a series of webinars we're putting on in lieu of our in-person conference this year. Just on a personal note, I really regret not being able to see all of you in person. I know that that's one of the things we look forward to every year. It gives us an opportunity to see folks face to face, which I know we're all missing these days. But on the upside, I had a reason to wear a tie this morning, so I'm pretty happy about that. So just a couple of housekeeping items here. This will be done with question and answer capability. So if you have any questions during the presentation, feel free to submit them, and I will be reviewing them as we go along, and Dana and I will answer them at the end. So with that, I'd like to introduce Dana Svendsen, who is part of our Occupational Safety and Health group. Dana and I are going to be spending the next hour walking through workplace safety considerations with respect to COVID-19. I know that's on the top of everybody's list these days, and as Dana will share with you a little bit later, we're starting to get some action on the OSHA front with respect to COVID-19. So we're going to be covering that. We're going to be covering some matters related to retaliation with respect to COVID-19. We'll be discussing the new state statute that deals with that issue, as well as the federal 11C statute and how it impacts COVID-19. So with that, Dana, if you wouldn't mind advancing the slide, we'll get started.
Very good.
So when COVID-19 first came to prominence back in March, OSHA really didn't know what to do with it. There's obviously not a direct standard relating to COVID-19. And one of the first things I thought was, how is this going to look from an enforcement perspective? So what the agency did is they issued some guidance fairly early on addressing potential standards that could be utilized in an enforcement action. And the most prominent one of those is PPE. I've been doing occupational safety and health for a long time, and one of the only upsides to COVID-19 is that I'm hearing the phrase PPE quite a bit in the news these days. Unfortunately, most of the time people get it wrong. And where they get it wrong is the masks that we hear about and that we mandate in our workplaces under the state order are not personal protective equipment. Personal protective equipment is equipment that is designed to protect the wearer, whereas masks are designed to protect those around the wearer. So OSHA is on record as saying they don't consider masks to be personal protective equipment under their standards. However, PPE could come into play if it's otherwise necessary to keep the wearer from getting the virus. So I haven't seen any enforcement activity or guidance as to what particular PPE might be involved in a particular job. I could see gloves as a possibility, but I don't think that enforcement under that standard is going to be incredibly likely. Next standard they referenced is respiratory protection, and that's 1910-134 under general industry. This applies only when the duties of your job necessitate respiratory protection to safely perform the functions of your job. It's going to be difficult for OSHA to enforce this. The agency doesn't want to see employers mandating that employees wear full respirators because that involves things like medical evaluations and fit testing and things that generally shouldn't be required of 90+% of all employers. So there could be a rare case where the exposure is such that might be necessary. I fail to see that those cases are going to be very many, but that is out there as well. Eye and face protection, there's a standard that covers those. There is some evidence out there that the coronavirus is transmissible through the eyes. So mandating goggles hasn't been something that many, if any, that I'm aware of, local jurisdictions have mandated, and OSHA has not been on record as saying that in every case that's required as well. So don't expect a whole lot of activity there either. Sanitation is one that you might see. It's kind of a general standard dealing with basic housekeeping, sanitary guidelines, things like that. Those guidelines are obviously in existence. and most employers should be following them. That's one I think that if OSHA wanted to take a closer look at, they might do so. But the big one is going to be the general duty clause. So if you could advance to the next slide, please, Dana. We're all aware of what the general duty clause is. It's section 5A1 of the Act, and it's a filler. It applies when OSHA doesn't have a particular standard dealing with a particular situation, such as the coronavirus. And this is the language of the statute right here. OSHA doesn't typically use the general duty clause unless they absolutely have to. And that's because it's generally harder to prove a violation of the general duty clause than it is a particular standard, because they have to show such things as recognition of the hazard, whether on an industry basis or on an employer basis, as well as feasible means of abatement. So and Dana's going to speak to this a little bit more in some of the enforcement we're seeing so far. What these COVID cases are going to look like is OSHA citing employers on the industry recognition that comes out of public health orders. We're all aware that Colorado has the safer at home and the great outdoors and whatever else they've come up with to name it. It's been kind of an evolving standard, but Colorado does expect that employers will comply with it. So I think what we're going to see is OSHA using those public health orders as a basis for industry recognition or employer recognition of the hazard. Similarly, feasible means of abatement, I think we're going to see them say, well, here's how you abate the hazard, you follow the public health order. So it's really kind of a guidepost for them to get where they need to be on the general duty clause violation. Next slide, please, Dana. So that's kind of an overview of the statutory and standard framework that OSHA probably will be using when they ramp up enforcement. One thing that comes up a lot, however, is outside of the actual enforcement of workplace conditions surrounding COVID-19 is record keeping and reporting. Of all the COVID-19 issues that I've dealt with and questions that I've fielded, this is one that I get probably more than any other. Employer has an employee who has tested positive for COVID-19. They're doing all the right things, making them quarantine, keeping them away for a couple weeks, doing all that. But they want to know, do you record it on your OSHA 300 log? OSHA, early on, to my surprise, provided some guidance that was very useful to employers. What they basically said is, unless you're an employer in a few select industries, such as healthcare, first responders, industries like that where exposure could be expected to be very high, unless you're in one of those injuries, you don't have to make a determination as to whether or not a COVID case among your workforce is work-related such that it makes it recordable on your 300 log. A few months passed and they changed their tune on that. They issued guidance that now requires employers across the board, not just in those narrow categories, to investigate employee exposures to determine work-relatedness. Now, when I first read that, I thought, this is crazy. How can employers possibly make a determination as to where somebody transmitted a virus? And the standard is it more likely than not that the employee transmitted the disease in the workplace? If it is, it's recordable. If not, it's not recordable. So that was my initial take on it after reading about the first half of it. The second half put my mind at ease a little bit. It said that employers must make a reasonable determination. It's not a case where every COVID-19 case in your workforce is automatically recordable. They even gave some guidance as to what kind of questions you should be asking your employees to determine whether or not the transmission was work-related. And the first one they put out there is, ask the employee if they think they got it at work. Well, that's not very helpful. But then they go on to say, ask employees if they've been in any situations outside of work where they think it was possibly a spreader event or transmissible outside of work. And that's fine but I'm cautioning employers to be really careful with that. You don't want to be in the business of asking your employees too much about what they're doing off duty. You don't want to say, have you been going to church too much? Have you been doing that sort of thing? I think the questions that you ask to make this determination have to go kind of along the lines of the state guidance. Have you been at any gatherings where there were more than 10 people, or have you been in any situations where you weren't able to maintain social distancing? Those sorts of things. One issue that comes up a lot is a lot of times employers will have little clusters at work where 4 or 5 people in the same unit or floor get exposed. And those are harder cases for employers to make the determination. And OSHA says in its guidance that it's those kind of cases that are more likely to be recordable. But you also have issues that, and I see my screen is frozen up, I apologize. You have situations where maybe employees carpool to work together or otherwise socialize together or live in the same communities. So how are you to know then that the exposure isn't related to an outside of the work activity or not? So in 9 plus out of 10 cases, I'm advising employers that COVID exposures to an employee at work are likely not recordable. And what I tell everybody is you get the first one free. If an employee comes to you and says, hey, I have COVID-19, no one else in the workforce does, it's obviously more likely than not that employee didn't get it at work. So your first one's free. If you start seeing little clusters or multiple exposures, that's when you really kind of have to dig a little bit deeper. But in my mind, it would take a really significant outbreak among your workforce to make those cases recordable. Another issue that comes up, and it goes hand in hand with record keeping, is reporting. When do you have to pick up the phone and notify OSHA of a COVID-19 outbreak? And there is actually the first citation that was actually issued with respect to COVID-19 down in Georgia dealt with this issue. But to me, this is even a harder one because a harder one to tell an employer that they have to pick up the phone and call OSHA, because hospitalizations are only reportable to OSHA, 1, if they're work-related, using the same analysis I just discussed, and 2, if the hospitalization takes place within 24 hours of the workplace exposure. That's going to be almost impossible for OSHA to show when the person contracted the virus versus when they went into the hospital and were admitted for treatment. So employers should go through that exercise. Oftentimes somebody won't be feeling well, so they go home for a couple days. Then they go to the hospital and it's determined that they have COVID-19 and they undertake treatment. You don't have to pick up the phone and call OSHA on that, even if it is work-related, because the hospitalization didn't take place within 24 hours. Same as fatalities. There's an 8-hour requirement from the time the employee passes away, but there's a 30-day requirement on that window. So if your employee, the last time they were at work was day 1 and they pass away on day 40, you don't have to pick up the phone and call OSHA on that, again, even if it's work-related. So much like record keeping, I think it's probably going to be the rare case where you have to pick up the phone and call OSHA. But it is, as Dana will discuss in a little bit, in the one of the cases that OSHA has issued some enforcement on, that is a question that's out there. So bottom line is, on record keeping and reporting, it's something you have to look at. And again, while the vast majority of cases won't be recordable or reportable, you do have to undertake that good faith review. So with that, I'm going to turn it back over to Dana, and she can talk a little bit about what we're seeing enforcement-wise. Oh, I'm sorry.
Well,
yeah.
Very good.
Got ahead of myself there. Other liability concerns, and this is where you're going to see a lot of the civil litigation is just under strict negligence, which basically is you have a duty that's owed to somebody, you have breached that duty, and they have suffered damages as a result. So, and the analysis will be, well, yes, you have a duty to your customers to provide a sanitary place of public accommodation. If you've breached that duty and someone can prove that got the disease at your facility, then yes, you may have some issues there. Again, though, the proof is going to be nearly impossible to show. I think where you're going to maybe see this is what they call the super spreader events. If you're hosting one of those and you have an audience of dozens of people or dozens of customers coming in without masks, and you don't mandate it, and you haven't cleaned the place up, and then all of a sudden those cases can be traced back to that spreader event, that's the kind of situation that's going to be troublesome. But again, we don't see that too frequently, fortunately. But for employees, the issue that's arisen is, well, how does workers' comp come in to affect all this? If a case is deemed to be work-related under comp, then the employer gets to take advantage of comp exclusivity, which means they can't be sued civilly. So it's going to vary on a case-by-case basis as to how workers and their attorneys approach these, whether they claim comp or not. Oftentimes, I think what we're going to see is, they're going to go ahead and take the comp benefits if it's going to be deemed compensable, because the proof issue is going to be so hard outside of comp. So, and I know the insurers out there are kind of pulling their hair over this and worried about having to cover all these COVID-19 comp cases. Some jurisdictions have a presumption that a COVID-19 case that your employee encounters, it's presumed that it was work-related unless the employer can prove otherwise. And that's a kind of a tough regime to work under. So that's kind of where I see COVID-19 workplace litigation going outside of OSHA enforcement, which now I will turn over to Dana to discuss.
All right, so what are the COVID enforcement trends that we're seeing from OSHA? Not much yet. And why is that? Well, it's been about 6 months since COVID-19 became an on-the-job threat to U.S. workers. So that lines right up with OSHA's statute of limitations to issue the citation. So we expect to see quite a bit of enforcement coming online in the coming days and months. So OSHA has opened 996 inspections so far as of September 10th involving COVID-19. 602 of these involved either a worker fatality or a hospitalization. And so you can kind of do the math, about 400 additional ones would just include probably complaints about workplace conditions due to COVID. Of the nearly 1,000 inspections they've done, these are really occurring in the hotspots in the country where we're already seeing large COVID cases. Almost a third of those occurred in OSHA Region 2, which is New York and New Jersey. And this is also where we expect to see the majority of OSHA enforcement in regards to COVID-19 issues. 255 occurred in Region 5, covering upper Midwest states. And here we are in Region 8. We've only had 14 inspections that have been coded as related to COVID. So around here, it'll be interesting to see what type of enforcement happens. But I believe that it looks like the East Coast and the upper Midwest are really going to lead the way in OSHA enforcement. So we've only seen a handful of virus-related cases so far. Pat mentioned one, the citation to the Georgia nursing home for failing to notify OSHA. They had 6 staff members that were hospitalized for COVID, and OSHA felt that at that point they obviously had noticed that that was a work-related occurrence and they needed to be notified. So that citation was issued. There was also citations issued to 4 separate Ohio nursing homes for not adhering to respiratory protection regulations. And again, that would be, that wouldn't be for your standard everyday mask that's required by the public health order. That would be for workplace required PPE, and likely in this case, I think it was the N95 mask. They must have had some sort of issue with keeping those in proper order or keeping enough of them on their workforce to deal with proper hazards that they're experiencing. And another one that's come up has been a citation to a South Dakota meat processing plant for not implementing an effective prevention program. And that has actually gotten some press that I will cover in my slides as well. So, why haven't we seen more enforcement yet? I think OSHA, they really need to get this right. They're in uncharted territory here. As Pat stated, there aren't very many standards they can really use. So they're going to have to go likely with the general duty clause for failure to protect the workforce from a known hazard that could be reasonably abated. They're going to be working, with their attorneys probably to even issue these citations to make sure that everything is in order and that they're going to stick. Even in run-of-the-mill cases, we usually see OSHA using most of their 6-month time limit to prepare proper citations. They like to be careful and they want the citations to stick. Also, worker advocates are definitely watching how the agency handles the early cases, and repeatedly Democrats and labor unions have voiced concerns that OSHA doesn't have a specific rule. There was even some litigation about this early on, and the courts found that the general duty clause is sufficient to protect the workers. Very recently, the New York Times actually had an editorial and called out the Trump administration for providing little incentive for companies to protect their employees. They referred to that South Dakota meat packing plant case, and they wrote just $15,615. That's how much a $52 billion meatpacking company was fined by the federal government for unsafe conditions that led to the death of 8 workers. They accuse OSHA of being asleep at the wheel, despite the coronavirus infecting 6.5 million Americans and killing nearly 200,000. They really laid into this particular company in this editorial. And it's obvious that the worker safety advocates and labor unions and other interested groups are feeding information to journalists to get this information out in front of the public. OSHA is not going to take kindly to this criticism, and they're going to want to be seen as tough on enforcement. So it should be interesting to see how they respond to this type of criticism. So we expect the enforcement to pick up soon. COVID-19 started having its effects in March, and in mid-March there started to be closure orders and people staying home. 55 of the 996 virus-related inspections occurred by April 20th. So that means for those first 55 virus-related inspections, the enforcement will be due in the next 4 weeks. So that's where we're going to start to see the enforcement. And about half of those inspections occurred in New York and New Jersey. Then we continue on with the data, and you can see that in the next month, from April 20th to May 20th, there was over 284 virus-related inspections. So enforcement for these are going to occur through mid-November 2020. So this is why you haven't seen the headlines about OSHA enforcement yet. They're still using their time to get the citations right, but by 2 months from now, there's going to be enforcement in over 300 cases. So I think that the answer here is just stay tuned. And if you are interested in this COVID-19 enforcement data, you can find it at the website that I've linked here on the slide in front of you. It's updated daily, so if you're interested, you can certainly look. There's a lot of different ways that they have evaluated the data and separated it out, so by industry as well as region. So lots of items of interest there, and you certainly could go look at your own industry on the data and see how the enforcement has played out there. And I think I'm going to pass it back over to Pat, so thank you.
Thank you, Dana. Just a quick note on the enforcement as well. Another thing that we're seeing a lot of are what we call rapid response letters, and this is what OSHA does when they get an employee complaint. And the vast majority of the activity that we're seeing really is with employee complaints. OSHA obviously doesn't have the resources to initiate a full-blown inspection, that Dana was talking about, but what they will do is send you a letter saying, hey, we've received this complaint that there's a risk of or a hazard of COVID-19 at your workplace. What are you doing to deal with that? And in the vast majority of cases, if you give them an adequate response, that'll be the end of it. So you want to be able to say that you're doing these sorts of things. You want to reference your state and local orders and say we're in full compliance with those, and provide some examples of policies that you've instituted, whether it's the symptom checks or the isolation requirements, the sanitation, all of that. And so compliance with those local orders goes a long way. Consider other best practices that are outside of those orders. Every workplace is unique and has its unique challenges. So take a deeper dive than just the public health order to see what you can be doing, and make sure you keep up with the changing guidance that's out there. I really do think that on employee complaints, it's going to be the more egregious responses or non-responses that would prompt an inspection. For the most part, again, given all the things we've talked about, how new it is for OSHA and how little they have to work with in their standards and the general duty clause, if you're putting forth a good faith effort, you're more likely than not going to be okay with respect to those employee complaints. Next slide, please. And here's where you can go to get that guidance on COVID. Next slide, please, Dana. Okay, so speaking of employees who complain, let's talk about retaliation. This is a hot topic now. Just if you Google COVID-19 retaliation, you'll see that there's a lot of activity all over the country related to this, and it always comes up in the same kind of scenario. I complained that my workplace wasn't doing enough to address COVID-19 concerns, and I was terminated, or I didn't want to return to work. We'll talk about return to work in a second, due to COVID-19 concerns, and I was let go. A lot of it relates to unemployment. You know, once the layoffs occurred and people were on unemployment, the opening took place, and then people started to come back, and what you were seeing was, well, I don't feel safe coming back. Can I still receive unemployment? So Colorado has promulgated some guidance as to when you can still be compensated and when you can't when you're on unemployment. So, but anyway, getting back to there we go. 11C retaliation is the traditional workplace retaliation provision as part of the federal OSH Act, and it's very straightforward. It's unlawful for employers to discriminate against employees who make safety-related complaints or who participate in safety-related inspections. Broad protection, protected activity under 11C is always very easy for someone to allege. I made a complaint, I was fired. That's it. Now it's the connection. What was the reason for my separation related to the safety and health complaint? And that's just like any other case of discrimination. That's usually where the facts come into play and where most of the argument takes place. Since the beginning of the pandemic back in March, OSHA has received over 2,500 complaints of retaliation. To my knowledge, they have not filed suits on any of them. And the reason that is because, next slide please, Dana. Most 11C cases don't go anywhere. And that's because there's no private right of action. The mechanism is OSHA receives a complaint and they investigate it. Now the investigation is done by a separate group of OSHA outside of the safety and health compliance officers that you would see show up at your workplace and determine whether or not any standards are being violated. These are investigators who do nothing but retaliation. They investigate claims under 20+ federal statutes, many of which do have private rights of action, whereby the DOL investigates. If they issue a no-cost finding, the employee can then go to an administrative hearing and seek damages there. 11C doesn't work that way. In order for damages to be awarded under 11C, the Department of Labor actually has to initiate the suit on behalf of the employee. So it's the government that is the named party. So because of their limited resources, we see those very, very rarely. Dana and I are working on one right now, but we don't run across those very much. So I'm not really concerned that there's going to be a whole lot of activity on that front, but it is possible. One issue that comes up in complaints under 11C are refusals to work, and this is again what we're seeing with respect to COVID. I don't want to keep coming to the office because I don't think my employer is taking the steps necessary to protect us. Those are really, really hard cases to prove. There's actually a regulation under 11C that states that work refusals are only protected if an employee has an objective, reasonable belief that there's a real and imminent danger of death or serious bodily injury. And then the cases where they allow those work refusals are really there's a girder that's about to fall and my employer is telling me to go work under it. Those really kind of, if I go under there right now, I could die type of cases. They also have, the employee or the government also has to show that the employee didn't have enough time to go through OSHA enforcement, make a complaint, and have it investigated. So with respect to COVID-19, these are things that are going to be really hard for the government to show on work refusals. That imminent danger and the reasonable belief is going to be tough. I mean, it's got to be the real egregious employer who's not taking steps enough such that a reasonable person would believe that a death or serious injury from COVID is imminent. So I don't expect a whole lot of activity there under 11C. Next slide, please, Dana. All right, the new Colorado statute. This is a statute that the General Assembly recently passed. It's somewhat analogous to 11C, but there are some differences. So it's all related to workers exercising their rights with respect to health and safety, but it is limited to the public health concerns that we're dealing with respect to COVID, as opposed to the federal statute, which covers any safety and health complaint. So one of the ways it's different from the federal 11C is that it covers more than just employers. Employers, certain labor contractors, public employers, which FedOSHA does not cover, and entities that rely on independent contractors for a specified percentage of their workforce. So those are the category of folks who are covered by this statute, and none of those entities can take adverse action against any worker who raises any concern about workplace health and safety practices or hazards. And here again, related to a public health emergency to the principal, principal's agent, other workers, a government agency, or the public, if the workplace health and safety practices fail to meet guidelines established by the public health agency. So basically what that means is it has to be a concern related to the pandemic and that somebody is not following all the rules. If an employee or somebody else who's protected under the statute raises those concerns, they're protected. Next slide. There's a second level of prohibited activity here. Now this one's interesting. The issue early on in the pandemic came up of whether employees could bring their own PPE to work. We were seeing some employers saying, no, we want you to use what we provide. So the state statute protects workers who voluntarily wear their own PPE, as long as, and this is important, it's as protective or more protective than what would otherwise be required. So if somebody comes in with and this is an issue that I haven't seen that I think could come up, is what happens if an employee comes in with a mask that has political overtones or has something that the employer thinks wouldn't be suitable for the place of employment. I would take the position there that that's not, the issue isn't the PPE, the issue is the clothing, what the employee is wearing as opposed to the protection it provides. But stay tuned on that. So here's another big difference between 11C and the new state statute is the procedure. As I mentioned, under 11C, the employee files the complaint, and it's up to the government from there. Under the state statute, employees will be allowed to file a complaint with State Division of Labor Standards and Statistics in the Department of Labor and Employment. And after those administrative remedies are exhausted, similar to an EEOC matter, they can bring a court action in district court. And the last one is interesting too. There's a provision in there that we don't see a lot, but it allows an employee to basically bring an action in the name of the state, a qua tam action, and seek relief for all people similarly situated, basically in the name of the government. That's we don't see that a whole lot, and I certainly don't think that we're going to be seeing those kind of actions in the future. But I do want, and here's another few differences between this and 11C. Applies to independent contractors. Complaints will be made to the Department of Labor and Employment and be investigated by them. 2-year statute of limitation, and fees, reinstatement, front pay, back pay, and in some cases, punitive. So full range of remedies here. Pretty robust statute of limitations. Another difference with 11C. 11C, the statute of limitations is 30 days. So this state statute gives employees a lot longer to think about whether or not they want to pursue an action. So yeah, after 90 days of administrative remedies, the complainant can go to district court. And here's the qua tam actions that I mentioned. And this is where, if you get one of those, $1,000 awarded for each separate violation, and the whistleblower gets 25% of the judgment. The state gets 75%. So hope that no one receives one of those out there. But again, I think that's going to be pretty rare to see that. So I wanted to end on, and I do have a question in here that I'll get to in a second. And please feel free to submit any more questions. We have plenty of time to talk about them. I wanted to, again, return to the refusal to work issue, because I think that's one that's going to, now that we have the state statute, which has better remedies and procedures that allow employees to bring their own causes of action, I think that's where we're going to see the action taking place. And there are going to be some implementing rules coming out under the statute. I haven't seen anything related to more guidance as to what is retaliatory, but I am taking the position that, similar to the federal anti-retaliation statute, that work refusals should only be protected in a very, very narrow set of circumstances. Imagine, if you will, a situation where any good faith refusal to work, that is in the statute, good faith refusal to work is protected. That could shut down the entire economy, because then all an employee would have to do is make a good faith argument that they are concerned about the COVID-19 situation at work. They wouldn't have to show that there's an imminent danger should they go into work. They wouldn't have to show that it's objectively reasonable, their fear. They would just merely need to show that I'm here in good faith to say that I don't think the steps you're taking are sufficient under the standard, under the circumstances, and I'm not coming to work. If that activity is protected and you can't terminate those employees, again, it's going to be a tough road to hoe. Now, you need to be following the state guidance that says, to the extent that an individual is vulnerable, you can't make them come to work. To the extent that somebody is living with somebody who's vulnerable, you have to make every effort you can to provide accommodations, work from home for that individual. But what I'm more worried about is just the garden variety employee who's scared of COVID-19 saying, you know what, my employer's telling me to come in now. They don't want to do it. So you need to look at those cases carefully. I think given given that you don't want to be a test case for this, if there's any way you can possibly accommodate remote work for individuals who have reasonable fears of the virus, then you should do so. And I think the vast majority of us have gotten used to working at home and can do so in many situations. But in those where it's just not possible, employers still have that right to, again, unless somebody's vulnerable or otherwise needs to be provided those accommodations, then in-person work is going to have to be done here. And hopefully the state statute is not interpreted as any more loosely than the federal one is. But stay tuned on that. Anyway, I've chatted long enough. We have a couple of questions here. Question 1, may an employer who is not subject to OSHA conduct health screenings of vendors, contractors, and employees entering the workplace, including temperature checks? What are the record-keeping requirements for these records? With respect to the first question there, all employers are subject to the OSHA Act. If you have one employee, you're subject to it. So I think what this question is getting at, though, is what if you're taking screenings, or can you take screenings of contractors that come in or employees of other employers who come in? And the answer to that is yes, you can. You should be doing, you don't need to go through the same types of steps that you do with your own employees. And frankly, there's not a whole lot of state guidance on this, but what I'm seeing and what I think is a good practice is that temperature checks for customers and contractors who come on, or if you have a relationship with the vendor or contractor such that you can get them to verify that their folks have done the symptom checks and all of that, that's a good idea too. But yes, you can require people coming onto your location to do the same symptom checks and temperature verifications that your employees do, and I think it's a good idea. Second question, what are the record-keeping requirements for these records? Great question. OSHA has in their standards a provision that medical records need to be retained for the duration of employment plus 30 years. However, that only applies to records that are made and kept by licensed healthcare professionals. So as I read OSHA standards, the kind of garden variety temperature checks and screening questionnaires are not medical records that are subject to any sort of requirement to be retained. I do believe the state has some language out there that they want them kept 3 months, which is a reasonable amount of time, I think, to keep them. So no real stringent requirements there. Next question is, do all complaints made about the employer regarding COVID-19 have to be saved for 2 years? I'm not sure what kind of complaints, whether that's retaliation or actual complaints related to a potential workplace exposure. But no, there's no specific time limitation that you have to save records of employee complaints. I always, keep them in the appropriate files for the appropriate statute of limitations that might apply, which would typically be longer than 2 years. So, but no, the answer is there's nothing OSHA specific or state specific with respect to records relating to complaints. If an organization had to demonstrate they had taken reasonable steps to protect employees, what type of evidence would be ideal and or permissible? Good question. It's the same. It's following the state and health guidance is a good start. But like I mentioned earlier, I think that it's good that the employer takes into account any unique factors in their workforce, unique either physical characteristics or situations where it's impossible to maintain social distancing, how you're dealing with those situations. Because my fear is, one, if you're not complying or at least making a good faith effort to comply with your state and local guidance, that's one thing. But if you are, but your workplace is unique such that guidance may not provide all the protection you need, there's certainly nothing stopping OSHA from saying that that could be a general duty violation because you either did recognize or your industry recognizes that there are certain hazards that go beyond what the state guidance is recommending. So again, the reasonableness really comes down to taking a look at your unique situations to see what more you should be doing. I was told that private nonprofit educational institutions are not required to keep OSHA 300 logs. Is that correct? That's a good point. And I don't know the answer to that off the top of my head because there are numerous industries that are not, even though you're subject to OSHA standards and enforcement, there are a lot of industries that are exempt from having to keep OSHA 300 logs, like law offices, other type of office settings, and other industries that through lobbying or otherwise were exempted from it. So I don't know if private nonprofit educational institutions are on that list. I'd certainly be happy to look that up and send a personal answer on that. But it's a good reminder that OSHA, by saying employers have to make a determination as to work-relatedness on COVID-19 cases, that does not mean that if you're otherwise exempt from keeping OSHA 300 logs, you now have to do it. And I should have mentioned that at the outset. It only applies to those employers who otherwise have to keep their OSHA 300 logs. So employers who have 10 or fewer employees, regardless of industry, you don't have to keep logs. And as I mentioned, if you're in certain industries, you don't have to either. So OSHA's guidance does not put any further obligations on you. We have a fairly robust return to work safety plan because our work involves children and we have very vocal employee base and are closely watched by the media. We would be able to require workers who travel out of state to quarantine stay out of our buildings for the recommended 10 to 14 days. Would we be able to require? And would we then be obliged to pay staff during this travel quarantine? Yeah, the answer is yeah. The state guidance does recommend well, let me back up. It used to be that the CDC guidance had the 10 to 14 recommended days after out-of-state travel. So I was advising clients to follow the CDC guidance. They have since rescinded that guidance and are now saying that employers need to kind of make that reasonableness determination on their own, which was kind of a head scratcher when they did that, because now it really allows employers to not have or doesn't allow them to kind of have that hook to say, here, the CDC says that we have to be quarantining these people. So that requirement isn't there. I still think it's a good practice. Now, on the issue of whether we have to pay staff during the travel quarantine, the answer is yes. Under the federal statute, there is a provision that requires up to a certain number of hours that anyone has to quarantine for COVID-related concerns to be paid. And I think that might be addressed in some of our other sessions here. Another question, aren't government employers, political subdivisions, exempt from OSHA? Yes. Federal OSHA does exempt state and local governments. However, some states who run their own occupational safety and health plans, New York is a good example. They have requirements for governments, but here in Colorado, that doesn't apply. We're a Fed OSHA state, so we don't have that obligation. So that is correct. Government employers are not subject to OSHA. Oh, good question. If an employer hires a nurse to obtain temperature checks, et cetera, of employees and contractors, do the OSHA record-keeping requirements apply? That's a great question. I think the answer is yes, because that is a medical record that is being kept or is being made at least by a licensed healthcare professional. So in that case, I would err on the side of caution and retain those records for the duration of employment plus 30 years. What if the employer who hires the nurse is a government employer? Yes, so if you're not subject to OSHA, you're not subject to the medical record provision. So yeah, if you're a state actor and you're in a Fed OSHA state that's not otherwise subject to OSHA requirements, and you hire a nurse, the OSHA requirements on medical records do not apply. Well, again, thank you everybody for attending. Those of you who are still on, we'll be ending the presentation at this time. And again, hope to see you at 1 o'clock. Thank you very much.